Yes, yes.
Lordship, considering the whole lunch motion pertaining
Huh?
to medical admission.
Hey, what medical admission not over as yet?
No, no, Lordship. It was extended, Your Lordship, till November 7th.
All right, today lunch means it may not be after lunch, right? This
Yes,
bench
yes.
is only till 1:30. It will be taken up before this thing. As soon as the matter comes, you be ready. Yes. What else?
The matter is posted after 4 weeks, but not reached last 8 weeks.
Why do you want the listing?
Challenged the GO, which was a
No, why do you want for admission interim
interim
order,
direction is required. Your Lordship. Interim directions.
interim direction?
Yes.
All right, Tuesday.
Much.
That it's a old matter pertaining to 2012
Huh?
out of the list.
Huh?
It's a matter pertaining to 2012.
12.
Moreover, the petitioner is a super senior citizen.
Huh?
Petitioner is a super senior citizen.
So file an application for urgent hearing. We will list it. I mean, there is can't be any doubt. It has to be heard. 2012.
Any areas.
No. Please file an application. We will fix a date. We don't grant fix a date by mention memo, right?
Right.
Yes.
This appointment of matter is there, sir.
Huh?
This is not listed for last 4-5 weeks.
Huh?
This matter is not listed, sir, for this.
Just now you
Request
made.
for lifting of the case, sir.
Huh?
One more time, case number arbitration, appointment of sole arbitrator.
Sole arbitrator. Next Friday. No. Yeah, but Mr. Not now. Make a mention at 3 when 2:30, not division bench, right? This is.
Okay, sir. Right.
I am in a different combination. You have to make a. Yes.
I beg to represent your lordships.
Ah.
Your lordships, the matter is covered by your lordships orders in a similar matter itself on page 117, your lordships.
117.
Yes, your lordships. Exactly the same. It's part of the same patch of 117, 117, your lordships.
No. Hundred
117, your lordships.
Oh.
It's an order passed by this honorable court in August, I believe. In WP 16074 of 2023, your lordships.
So where is your environmental clearance matter?
Your lordships, it is part of the batch, your lordships, that is now presently in the NGT, and all other companies based on this order have been granted relief to continue with the operations, your lordships. The aspect of environmental clearance is now being decided in the NGT. However, this honorable court, the only change would be the OA application, your lordships. The number, instead of 51, it would be 123. And all matters, I've included on page 14 also, all the matters relating to the same reach of mining have been packed together and are being heard by the Honorable NGT, your lordships. That's OA number 51, of which order your lordships is now reviewing. OA number 68, OA number 146, and OA number 123, your lordships. Now, all the other OAs, there are several companies, your lordships, all the other.
No, madam, you accept the point you are saying everything else.
Yes.
The order is in violation of section 19(4) because it has been passed without affording an opportunity.
Yes, your lord.
Except that you are saying everything.
Yeah.
Who will decide whether OA number has to be changed? You can't decide.
Yes, your
You
lord.
are telling us that this except OA number has to be changed.
Yes, your
it's
lord.
not the way, madam.
Yes, your lordships. The order.
Yes, Mr. What do you say?
I appear for 8th respondent.
This prima facie, yes, correct. This. What do you say?
I appear for 8th respondent.
Yes, we will have to issue notice.
Yes, notice.
Learned senior counsel for the appellant petitioner. Yes.
Your Lordship. Your Lordships, the interim order to allow
No, no,
the
Madam, first
activity
tell us
may be
this.
considered. Yes, Your Lordships.
The order impugned was passed in the month of January 2022.
Yes, Your Lordships.
So what were you doing for 1 year and 7 months, 8 months now?
Your
10 months?
Lordships, we filed the counter after the fact of the ex parte orders, Your
They are
Lordships.
entitled.
And
We have recorded your submission. First day of hearing the petition cannot be allowed when you have taken time of 1 year and 9 months in approaching the court.
Your Lordships, if I may.
This order was passed on 23rd January 2022. All right. Learned senior counsel for the heard on IN. Next.
Lordships, if I may state so, the respondents are here, Your Lordships. And similar companies in the same reach, all of the agreements are of the same reach, Your Lordships. They have been allowed by the respondents pursuant to all the interim orders, right from 102 to 122.
After the order was dictated, learned senior counsel for
And here the interim, Your Lordships, because it is required, Your Lordships, an early date, Your Lordships.
so we should take out the service, right? We should take out, now leave the court, serve the respondents, get it them served, and 1:30 allow your petition. This is the prayer.
Your Lordships,
Who
that
will
is-
take steps, madam?
we will take steps.
Then take steps.
Yes, Your Lordship.
And once they are served, mention. We can't fix in anticipation when you will serve. This is too much. We
Yes,
have
Your-
dictated order despite that you want us, you're a senior counsel.
Yes, Your Lordship.
This goes against your conduct as a senior counsel, what we have dictated. That even after dictation of order, you are arguing the case.
I'm
Unfortunate
really
matter.
trying to bring it to Your Lordship's attention that it's a covered matter of my own case in the same reach, Your Lordships. However, Your Lordships, I'll take steps, Your Lordships. I'm obliged.
My lord, and item number 2, my lord, I beg
Ah.
copy of the petition, my lord. The challenge.
All right,
to
lord.
my lord, is section 16(2)(c) and section 41.
Yes.
TSHC Act, my lord. The lordship has in similar matter has passed.
Yes.
Interim orders on 10% of deposit. on
18th,
demand, my lord.
18th February, 18th October.
Yes, my lord. 18th October and even on 20th October, my lord. Lordship has
Okay.
passed an order on 20th October too.
Yes.
Lord, may I make
Learned counsel for.
one respectful submission?
Yes.
My lord, having regard to the prayer that the petitioner is asking in this writ petition, eighth respondent may not be a necessary and proper party is my respectful. State of Andhra Pradesh is being arrayed as a respondent.
I don't appear or file an application for deleting at this stage. How?
My lords can strike off under rule 16A of the writ rules. That is why I am making a submission. If it appeals, consider. Otherwise, I'll come up with a counter.
Please. We have not applied our mind to this aspect whether state of Andhra is a necessary party.
Great.
We don't know if eventually if it is found. You don't appear if you have no stakes.
Great.
And then I'll also cooperate, I'll appear there also, my lord. In the other three directions, what your lordship had given.
You are saying that there is no demand?
My lord, they raided, my lord, and
Huh?
they just called us. On demand, I'll deposit, my lord, and also cooperate with the investigation also.
No, no. You are at present, there is no demand. When demand is made, file an application, we'll consider.
My lord, may I,
Presently, there is no demand, right? How can we pass an order in anticipation?
My lord, once they call, my lord, without giving any, demand in writing, if they force us to make any payments, my lord, we will not have any protection.
No, no.
Because the lordship order says on
This-
demand.
this can't be. Mister, there is no demand, right? How can like anybody force? We don't know how without raising a demand they can recover the amount from you. What amount is to be recovered?
Generally, my lord, may make one submission subject to lordship's leave, my lord, only one submission. Generally, my lord, once they come and raid.
No, we are, Mister, you will be, as and when the demand notice is issued to you, you are at liberty to approach this court. We will see so in the order, liberty is reserved to the petitioner
A
to
blanket order
approach
cannot
this
be
court.
passed, I think.
Liberty is reserved to the petitioner.
Yesterday, my lord, there was a search operation conducted, my lord, in the premises of the petitioner company. My only
What is this, Mister? He is appearing,
Yes,
right?
I apologize. I
So then you will start this thing,
I apologize.
notice, yes.
Director represent. Petition is filed questioning the auction sale which was supposed to
Give
be.
that order, madam. Yes. That
Petition
this
is
thing,
filed questioning the auction sale.
Satyavati tender. Yes. Ah,
Questioning the auction sale which was supposed to be conducted on 1/11/2023 lordship.
ah.
As there was urgency, we have filed it on 30th, was number today, and auction sale is also being cancelled. So liberty may be given to withdraw this petition to approach the debt recovery.
Learned counsel for the yes. Serious matter, Mr.
Yes,
You should take notice,
Yes.
right?
Restaurant number 2, 3, 4, my lord,
Huh?
appear. Restaurant number 2, 3,
Ah.
4.
Hmm.
I'll file report.
Immediately, none of us, our relatives are there. Supposing it would, how you would have felt? This should be the response from the state. This is what we want. Immediately, you should have said, sir, it's my personal duty to ensure that it is put to this thing. It is made operational. You are saying 4 weeks. And tell them, Mr. We will proceed. We will not hesitate. Tuesday, if they don't, this thing, we don't receive the compliance report, we will proceed against you. Tell them. All right. This public interest litigation has
To appear on behalf of the appellants.
uh,
All the 4 writ appeals matters arise out of a common order of the learned single judge.
yes.
19th April 2022, members.
Uh,
19th April 2022, the order starts at page 7, members.
uh,
The learned single judge had remanded the issue back to the special tribunal to adjudicate the issue afresh because the then collector had not considered the aspect of limitation. Now, Manoj,
what's wrong?
no. The development is not post filing of the writ appeals. The appellants have entered appearance before a special tribunal. Lordship may direct. Only dispute is Manoj, the learned single judge had directed the matters to be expeditiously disposed of within 4 months. Till now, no action is taken.
We'll direct.
And the
Yes,
respondents
Mr.
also have not entered.
Further period of 2 years. Mark the presence in the No. Listen to me. Young, that's right. This needs to make it 1 minute. The shit doesn't come overnight merely by taking work. What happens when you are dictating? I have to do particular what process. The process also discussion. Once I dictate, you can tell that sir, you said it's easy. Obviously, it's mistake. No, no, it's all right. I'm telling you. This nobody will tell you. Your senior they will not tell you. That's all. I'm telling you. Otherwise, see, I would not have told you, right? I want you to improve, that's why I told you how to be able. Never. You tell after the order is now. Sir, you dictated one electrician, it will be single. The thought process is incorrect. Yes. Ah. Next.
May please your lordship.
Ah, yes.
Return file.
Who is appearing?
Myself, your lordship, Surya Balu Mahendra.
You are not visible, that's why. That's who is appearing. Yes, yes, please.
Writ appeal file agreed by the order, page number 9, your lordship, wherein a direction has been issued to register the documents basing on a unregistered document. And your lordship, section 17 of the Registration Act says that without registration, the property cannot be transferred, and this is laid down in the writ appeal order passed by this.
Yes. You are appearing?
For respondent number 1 and 2.
1 and 2. And remaining respondents you don't represent? Third on the question of admission. Learn it. Yes. Next.
Your lordship, subject to your lordship permission, your lordship, interim order may be extended, your lordship.
Interim order is already there.
Yes, your lordship.
Interim
Your
order,
lordship, we have
if
filed,
any shall continue till next date of hearing. Yes.
your
Next.
lordship, we filed IA 4 of 2023 for impeding the other parties in the other petition, your lordship, because
Why?
we have common order.
Other parties?
Your lordship, there is a common order passed in in 4 writ petitions, your lordship, along with the 16310.
No. So you will have to file 4 appeals. You cannot challenge one appeal and impede everybody.
Much obliged. I'll take steps, your lordship.
Learned counsel for us. So
That I am appearing for the respondent corporation. And already there is an interim order granted by this honorable court to maintain status quo with regard to possession. And Milord, your lordships have further directed that the appellants shall not restrain the operation of the buses from the subject land.
nobody is appearing.
Yes.
None for the appellant. Mark is present.
Please, Srikanth, details of it.
Ma'am,
In this matter, I am appearing for the fifth respondent, Milord.
No.
The counter is being filed on Monday, Milord. Your lodge may have it on next Friday if it is convenient to your lodge.
Thursday.
Counter on behalf of the fifth respondent is being filed.
All right, learned senior.
Yes, sir.
Ah.
Well, their report is filed by the Pollution Control Board. Now, they said that the sixth unofficial respondent has to take necessary steps for correction of necessary steps within 1 month. Now, the Lordship may so please us direct to the Pollution Control Board whether the unofficial respondent complied with their own direction. I am not seeking any other. Now, your report is filed stating that, that there was directions to comply the industry within 1 month.
Ah.
Report is filed before this honorable court.
Milord, I am informed that they have been complied with,
11/5/2023.
and the counter would say all that.
You are taking action, you are seeking action against respondent number 5,
Yes,
right? Is he not entitled to file the counter?
No, I am not asking, I am not.
Just praying for time, we are adjourning it to next Thursday. Let him file counter, then you, whatever, we will hear you, whatever you have to argue. Learned senior counsel for respondent number 5, prays for short accommodation to enable.
Your lordship can accommodate on Friday, Milord.
Huh?
Your lordship can
Yes.
accommodate on Friday.
Friday,
Lordship, I have 14th, Lord, sorry, Lord, 15th, Milord, because I have a Supreme Court hearing. 15th of now.
watch on. Let the writ petition be listed on 15th of November 23.
Oblast. Oblast.
I beg to represent on behalf of CH Venkatraman, my lord, petitioner advocate. I may be permitted to withdraw the writ with liberty, my lord.
Which case item?
13, my lord.
13.
Yeah, I,
Learn it to with. Huh?
With liberty, my lord.
Liberty to do what, mister?
To file fresh writ petition because the thing is that, my lord, they are challenging the maintainability that the company as on today is not alive.
the last
And
bit of
we
hearing,
have-
Milord, I beg to appeal for the respondent number 1. I brought to my lord's time notice, Milord, that this company is to dissolve under order dated 21.
So he is
We are
withdrawing the writ petition, right? Your objection has been sustained. So he
Yes.
has also accepted it. That's why he is seeking.
Yeah, that's all.
Mark the presence, learned counsel for the petitioner. No question of granting the liberty. That's it. That new entity whatsoever can always file a petition. This petition is filed by a person who is not in existence, right?
Yes.
My lord, we are
You are admitting it.
within 15 to 20 days. This is already in pendency in NCLT, my lord. With regarding to the revived petition, my lord. That's what we are seeking, my lord. Once it got revived, we will file a fresh writ petition with regarding the very same. That is the only reason, my lord.
Learn.
I'm so applying.
mobilized.
Huh. Oh, what is it? Oh, yes. So we had last date, we had said something. Ah. No, no. So see, This you have disclosed the amount of budget and this thing. We'll deal with it. Petition is admitted for hearing. Please.
May I please? This is the yesterday's batch millets. Let's have segregated the millets. Item 15 millets and 25 millets are the appeals filed by the state with respect to the lands in Alwal village. Millets arising out of urban land sealing proceedings.
15 and
25 millets. Are the appeals by the state, and all other matters millets are also tagged out millets with these writ appeals since the subject land is one and the same.
It's a case where we were being told that other matters have nothing to
And
do.
millets item number 18 and 20 is concerned, they are Sheikhpet village lands, not this subject land. Yes, millets. And item 21 is with respect to Kondapur village lands. As I have just
No. So what I mean,
they'll have to be detagged, millets, those three matters. And these matters.
Which matters do have to be?
I have just passed the minutes.
21.
21, 18 and
21.
21. And millets 18 and 21.
18 and 21.
20 millets, I am sorry. 20, 18 and 20.
18, 20 and 21.
Yes, master. There, I have given the slip millets with respect to different villages millets.
No, but the it may so different villages means it should not be heard. Like if the issue is in common, then what is it?
That appeal number 166 of 2018. 2018.
Huh?
2018.
There is another batch millets with respect to Kondapur villages. Writ appeal 160.
No. So what do you say? Who appears in 18, 20 and 21?
18 I am appearing, my lord.
So he says that it should be detagged.
It is not
D-linked, right? Your case also should be D-linked, they are saying. Different. All right. 18, 20 and 21. Then 21 who appears?
21 we are appearing.
So it should be D-linked, right? But it will come in the next week, madam. Not like D-linked means it's not like freedom from arguing, right? It will come next week. Learn it. Now rest can be heard, right? All the cases remaining can be heard.
Milord, item number 15, Milord, I filed a complete application, Milord.
We will consider, let him argue first. What impediment, mister? If you have independent right, you file a petition. What is in state's appeal? Something like that.
Impugned order, Milord. We are sorry, like impugned
You
order.
cannot, mister, in their appeal, please appreciate, mister, in their appeal, we will not adjudicate your right and hold that you have a title in respect of land, whatever. We don't know what is the subject matter. Nobody has told us. But in his appeal, we cannot adjudicate your right. If you have any right in the property, you do whatever you want to. File a petition, sue, do whatever.
Milord, that
We don't know.
ULC proceedings, Milord, which is covered our survey numbers also. Milord. That is a.
Plus, there are
Mr. No, what is your attempt, Mr. Ramna? No, in that day, we were not inclined to hear. Or that day you insisted and then told us that I am not appearing in the case. We dictated till 5:30. Now today, today we are trying to hear the case. We are not permitting the appellant to open.
No, Milord, sorry, Milord, I'm not, I'm saying that I'm the implete petitioners, Milord, to bear up. So
We will.
to the court.
We are under an obligation to decide all these applications. What is they are seeking adjournment, right? They are not permitting you to appear.
Sorry.
Or you are not ready.
I am ready with the facts.
You are not saying anything. It's your appeal, Mr.
I'm informing that. Milord,
I have prepared a brief synopsis, Millets.
Yes.
Millets, the writ appeal, Millets.
1438.
1438, Millets. Is arising out of an order passed in WP 16803 of 2008. And Millets, in all other writ petitions, Millets, this order has been relied upon by the respective petitioners, Millets. And Millets, before going into the Millets, the facts, Millets, I'll just state few facts.
1 minute.
The writ petition was filed by
1 minute. One. Who is first respondent?
First respondent is the special officer, Millets, and competent authority under urban land sealing.
Urban land ceiling regulation. What is the order dated 23rd May 2012? All right, you go ahead your own way.
Minutes.
Yes.
Plus the writ petition was filed by two writ petitioners, respondents 1 and 2 minutes. Plus the Heritage Estate and Holdings represented by its managing director and Ashwini Datla. Yes. The second petitioner is concerned. She has filed minutes WAMP 793 of 2017 in this writ appeal after the writ petition was second respondent, perhaps in the writ appeal, second respondent. She filed a writ MP minutes WAMP 793 of 2017.
What?
That was ordered minutes. I am only saying she minutes filed.
You are telling us facts, right?
Yes, minutes.
So then they have filed a petition.
Before going into the facts, I am only saying this. She withdrew her claim in the writ petition through WAMP's.
Who withdrew? Petitioner number 2.
Yes, minutes. Writ petition number 2. And she minutes has applied.
1 minute.
Yes, minutes.
Petitioner number 2 in WP 16803.
Yes, minutes. Of 2006.
Of 2008, no?
8 minutes.
8.
Yes.
So what? The petition has been allowed. How? When she withdrew?
In this writ appeal, she filed a WAMP 793 of 2017. A miscellaneous petition was filed. WAMP 793 of
WAMP
793 of 2017.
17.
Yes, minutes. And she has withdrawn her writ petition by order dated 11/4/2017.
Withdrawn the writ petition?
Yes. And she has 11/4/2017 she has withdrawn.
No, her writ petition has been allowed, right?
Allowed. Pending this appeal, she has filed an application for withdrawal and she has approached the authority for regularization as per the prevailing government orders.
Which is the order?
11/4/2017. And she has applied for regularization and she has got the regularization. This is the one aspect. Plus the petitioners claims to have purchased the property on 29/7/2006 minutes. And they challenge minutes the urban land ceiling proceedings and the government GO exercising power under 34 in the year 2008. Unless the GO was passed on 4/5/2005. By the date of the GO, unless the petitioner has got no accrued right over the property. It is only after the GO was issued and subsequent proceedings up to 10/6 and possession was taken over. The petitioner purchases the property on 29/7/2006.
So therefore had no locus.
They have no locus at all is my first submission. And the learned single judge records a finding that the petitioners or their vendors were not put on notice. That is the ground on which writ petition came to be allowed.
So therefore the question of serving notice does not arise.
Yes.
Then
that's on 20th. It's a fact, 30th January 1996. in the earlier proceedings, the first respondent urban land sealing competent authority has deleted these lands from the purview of the urban land sealing. That's on 29/9/1980. Master plan was extended. That's including these lands into the, and these lands were notified as a for residential purpose. In the year 1998, my lords, you may kindly have a look at the GO, my lords, and under passed under 34 at page 146.
146.
Yes, my lords. This is dated 4/5/2005. The special officer relying on the Atia Muhammadi Begum's case, my lords, has exempted all these lands under the purview of the urban land sealing. Lords may kindly come to page 7. What are the parameters which were considered by the authority? And before going to that, my lords, the submission that subsequent change of the Adikesh Reddy judgment, the authority has reopened the proceedings. That is not correct, my lords. The order of the special officer is on 31/1996.
Let us see what first learned single judge is read.
Yes, my lords. Page 177 is the order, my lords, passed by the learned single judge.
So what happened? You have not told us the facts, Mr. Only purchase the land. That's it. Thereafter, what happened?
My lords, thereafter, my lords, they challenges, they files the writ petition challenging GOMS 580.
To set it.
My lords, the original declarant, Ghulam Muhammad and 19 others, my lords, have filed their declarations declaring these lands before the authority. Then, my lords, initially on 31/1996, the first respondent exempted these lands, my lords. Then it was brought to the notice of the authority in the year 1998, and thereafter government remanded the matter before the special officer. Pursuant thereto, my lords, on 23/12/2005, 8/4 and statement under 9 was issued, my lords. 8/4 orders and statement under 9. On 31/1/2006, my lords, notification under section 10(3) was issued, my lords. On 25/2/2006, my lords, notices under 10(5) was issued. And 28/3/2006, orders under 10(6) was passed, my lords, authorizing the officer to take possession. 29/4/2006, possession of the property was taken. Let's at no point of time, neither the declarants nor the my lords, the vendors of the petitioners challenged these proceedings. The petitioners claims to have purchased on 29/7/2006. They impugn the GO and the subsequent proceedings in 2008, my lords. Minutes, the 10-3 minutes was issued on 30-1-2006 and 10-5 on 25-2-2006. On 28-3-2006, 10-6 was issued and possession was taken on 29-4-2006. Thereafter, minutes, the petitioner purchased on 29-7-2006 and he challenges the GO of the year 2005 minutes in the writ petition after a period of 3 years, more than. Then the
1 minute, madam. In that senior advocate's case, we have taken Rachna Reddy. Only say that one part that call. That Rachna Reddy's case first submits that issue notice, right? That's all. Don't write anything. IA, it's a issue notice on main and IA. That's all. Notice on behalf of these two persons is accepted. Issue notice to remaining respondents. Yes.
Page 146 is the GO minutes, the order under section 34. 146. Minutes, the Lordship may kindly have a look at the minutes, the references minutes in the GO.
See, Mr. The only point in according to you in this case is that they had no locus. If they had no locus, you succeed. Otherwise, if they are able to establish, then perhaps you cannot defend this order, right? Because it has been exercised. So motu powers have to be exercised on not at the dictation of somebody else. In this, the finding recorded by learned single judges that respond number 2, one asked the respond number 2 to exercise so motu power. Exactly. And thereupon this order was passed. That can't be done. The only thing is prima facie about locus.
Yes.
Correct?
I'm grateful. That's the sale leads of
Mr. You should Mr. In the beginning you should tell these are my submissions 1, 2, 3. Then elaborate. You are only this thing petitioner number 2 has withdrawn writ appeal. Then this thing. Then 10-6 issued. What? It has to proceed in a systematic way, right? Like first, you said that there are no locus. What is your second submission? How no notice was issued? That is incorrect because he is a subsequent purchaser. What else? These are only 2 submissions. That's it. We have got it. What
14,
else?
Page 14 is their sale date. That shows minutes dated 29-7-2006. And even
so
they
this is admitted, right?
Yes,
this is not in dispute that they have purchased it. So what else then?
And the GO which was impugned in the writ petition was put to challenge by one Navabharat society members, and they withdrew that GO.
Which GO?
The GO which was impugned in the writ petition.
Which GO was impugned in the writ petition?
The order passed under 34 minutes was impugned in the writ petition.
What if there has to be some date or no date?
4/5/2005 minutes, UMS 4580, dated 4/5/2005, are the orders passed under 34 of the ULC. That was challenged by one society minutes before this court.
That doesn't make any difference, Mister.
And
if 100 persons are aggrieved and one person withdraws the writ petition, will you argue against 99 that one person has withdrawn? So how does it matter? They want to prosecute. He has withdrawn. Be happy.
As regards the locus and almost I have passed on a few judgments minutes.
So these are your only 2 submissions, right? So what are the judgments?
Minutes 2002 judgment minutes where minutes the Atia Muhammad's case minutes was not the correct law held by the Honorable Supreme Court.
Which paragraph? You have not written paragraph number here. What proposition you don't write?
Minutes paragraph 11 minutes. If the expression commencement of the act is read with reference to the aforesaid explanation, the area of doubt about the correctness of the decision of Atiya Begum case becomes very narrow.
No, you are on the issue of their locus, right?
Locus, my lords.
Now you are fighting a decision on merits. So what is it?
Page 20, my lords. Go to page 20. I am sorry, my lords.
No, the choice is yours, Mister. We asked you twice. Third time we are asking any other submission. You have said there no locus. And second is that the finding that the notice was not given to them suffers from non-application of mind in as much as there was no question of giving them any notice. That's what you have said.
This is the judgment, my lords. Page 2016, page 20, my
And
lords.
if you want to argue the matter on merits, then go to Atiya Mohammadi and this Adikeshwar Reddy and whatever. We don't-
2016, 12 SCC, 493, my lords. Page 20. Para 2, 3 and 6, my lords.
Yes.
Our attention was drawn to the original records, the order on section 8.4 and 9 and notification issued under 10.1, 10 and 10.3 of the ULC Act and possession certificates in respect of each case respectively. All the lands which are subject matter in these appeals have been purchased by the respondents herein from the original declarants land owners during the years 91-92 after the order under 8.4 of the Act was passed and notification was issued under section 10.3 of the Act. The same was followed the issuance of notice under 10.5 of the Act to the declarant, calling upon him to deliver possession of the land declared as surplus. Indisputably, the respondent has purchased the said property after the notification was issued under 10.3 of the Act. However, no person is permitted to transfer the title of excess vacant land after the publication of notification, which is prescribed under section 10.4 of the Act. 10.4 minutes was extracted. Then para 4 minutes. We have examined this aspect, having regard to the undisputed fact that the respondent has purchased the property from the declarant, which is vested with the state government under 10.5 of the Act, in terms of section 10.3 of the notification. There, yes, and para 6 minutes. And the one more aspect, minutes, the petitioner was claimed to be in possession was minutes the contention they have put forward. And the learned single judge said minutes nothing on record to show that the possession was taken over. Minutes, that is not left open for them minutes to contend, and in fact minutes possession was taken over on 29/4/2006.
Just the flag. Yes.
And minutes the possession aspect and all minutes the latest judgment as of 2023 SCC online is 1331 page 35 to 39 minutes. I'll just only read one paragraph.
Yes.
Paragraph 35 minutes on page 48. In view of the discussion above and having regard to the following, that there was a serious dispute with regard to taking of possession. 35 minutes. Conclusion minutes.
Yes.
In view of the discussion above and having regard to the following, that there was a serious dispute with regard to taking of possession of surplus land, that there was a delay about 7 years in filing the first writ petition from the date when the possession was allegedly taken by the state after publication of vesting notification, that no documentary evidence such as khasra or so and so for the period between the alleged date of taking possession and filing, that in the earlier two rounds of litigation, the as regards the possession and minutes delay minutes, and there was no challenge to these proceedings by the original declarants or by the vendors of the petition, and their own their link as well shows that the minutes 2005 is their inheritance of title, while the proceedings were initiated by the second respondent in 2003 itself. As regards this case, my lords, I am on the locus and all, my lords. The other batch, my lords, I will have to verify whether with respect to the facts of each case, my lords.
Huh? So which case? This is WA 1438 only you have argued.
Yes. The other writ petitions which are tagged on, my lords, with this batch. And the other writ appeal is concerned, my lords, except relying on this judgment, my lords, no merits were discussed, my lords. The writ appeal 28, my lords. Writ appeal 28 of 2014. Item 25,
This is not connected, right?
Item 25, minutes.
Same point or?
Same point, my lords. The writ petition was allowed relying on the judgment of the earlier order in the 1438.
So same, right? So why? So these two appeals we will take up. Anything else?
And here also, after this order he purchases. And after the order GO is set aside, they purchase. That is their claim. 2007 they purchase. In the other case, in writ appeal 28, my lords, their sale lead is appears
So same, right? I mean, same reasoning. After 10-6 they have purchased. Yes.
I am opening for the first response.
Ah.
They are saying that I don't have the locus. Point has been discussed by the honorable judge, single judge, your lordship.
No.
In this case, my sale lead being, my vendor has purchased in the year 2003. Your lordship, at page number 31 is the my.
Mr. This, you have not given him synopsis. You have purchased on 29/7/2006. Yes.
I purchased in the year 2006. Is the second sale deed your lordship? Original.
Whatever.
Original.
You filed a writ petition, right?
Yes.
That is after declaration under section 10(6).
My line of argument is this, your lordship. Notice has not been issued either to the original Patada or the subsequent Patada, subsequent the purchases after making the layouts were purchased. All the proceedings show the proceedings have been done in favor of against the dead person. So, no notice was issued from the Patadas to me. So, I am the only the person after purchasing I came to know it.
So who sold you? The dead person?
No, your
Lighter vein, Mr. All of you are so serious that not even smiling. So proceeding taken against dead person. So dead person sold the land to you from there. In your dreams he appeared that I have conveyed to
before
you.
dying only he sold it. He sold
What is, Mr. You understand? Like the dates are correct. You have purchased on 29/7/2006, correct?
Yes, sir.
So therefore, no notice was given to you, and fine.
My
There,
case of argument is either notice was not issued to the Patadars or subsequent purchaser, and who is the subsequently finally I have purchased. So to me, notice cannot be issued because the reason is I purchased in the 2006. But my case is before this honorable court is all the proceedings have been done against the dead person who was a Patadar. And notice not either was issued given to the subsequent purchase. So this was, your lordship, examined by the learned single judge. And given a finding, your lordship. 180.
See, Mr. The argument is slightly different. What has he argued?
Their argument is in respect of the locus.
Answer that.
The locus.
Notice issued, not it issued, that dead person accepted it. That no notice was issued to him, he did not do it any lifetime. The question is your locus. How can you challenge the order passed by the state government under section 34?
The reason,
that is the argument. We don't know the answer. You will have to tell us.
Yes. Your lordship,
if you have any answer.
The answer is in this way, your lordship. Because no
notice.
no notice was issued to my purchaser or anyone, and without in violation of the ULC Act, all the proceedings have been done.
All.
So
That's it. Anything else?
yes, your lordship, that has been discussed. with your
Urban
lordship.
land ceiling matter.
Page 184.
1 minute. Yes.
Your lordship, 10 subclass 2, 10 subclass 2 specifically says, after considering the claims of the persons interested in the vacant land made to the complaint pursuance of so and so, the complaint shall determine the nature of the deemed fit. At any time, the notification under section declare the excess from such land publication. So, and also the rule 5 subclass 2 says, your lordship, notice has to be given to all the interested persons. In this case, no notice was issued to the interested persons, your lordship. So I step into the shoes of my vendors. Your lordship, kindly look into the page number 31, which I filed my link document, your lordship. Page number 31, which shows that my vendor has purchased in the year 2003. Page number 31, your lordship.
Date?
Sale deed dated, this is sale deed dated 4/3/1 of 2003, 30th December 2003.
So therefore the notice should have been given to your vendor.
Yes, notice.
And since it was not given, therefore it is liable to be struck down.
Yes, struck down. And one more important thing, your lordship.
Yes.
Just I want to show the proceedings which have been page number 151. Page number 151.
150. Yes. Yes.
In the proceeding itself shows that the original Patadar was expired on the date, and they have stated in that proceedings at page number 151, it has been the person is expired. Against the dead person, all the proceedings have been conducted. Page number 151, serial number 4, Ghulam Ahmed, from whom I am claiming the rights over the said property. And page number 184, how the learned single judge has dealt with this issue, your lordship.
Yes.
Last para. Assuming that the GOMS number 58C and the consequential order dated 23/12/2005 passed by the first respondent are valid and legal, it is evident that the petitioners or their vendors are not put on notice. The extent covered by the order was fairly large.
No, Mr. The order was passed in the year 2005, right?
Yes.
All previous orders prior to your purchase, how the authorities could have found out that you will one day you will purchase it and therefore notice should be given to you in advance. They did not have the assistance of an astrologer. They would have known.
Registered documents are a public document. Law has been laid down in respect of this issue. When there is a public document, they are aware of it. And Patadar passbooks also issued in our vendor's name, revenue authorities. This issue is that also has been noted down in the subsequent paragraph, your lordship, at page number 185. I request the
Yes, yes.
The extent covered by the order dated 30th/1/1996 was fairly large, and pieces of the same was transferred in favor of considerable number of persons and agencies.
Right. Yes.
Answer for that, your lordship has posed the question. For that, the learned single judge has dealt with this issue.
Yes.
The respondent did not choose to verify the persons who are in actual possession and enjoyment of the land. Even where a land within urban agglomeration is covered by a master plan published subsequent to Act came into force, the state of affairs that exists as on date on which the matter is examined afresh.
No, please tell us about your locus, Mr. First, then go on to merits. Locus.
Your Lordship, my locus arrest in this.
Locus is by virtue of sale deed executed on 29/7/2006. Correct?
No, 2003, Your Lordship, my vendor has purchased. From him, I purchased in the year 2006. So,
Therefore, you are locus.
all the proceedings were done behind.
What legal representative of your vendor didn't do anything, sold away the land to you?
Your Lordship, because he has.
Because they knew that you will fight it out before the High Court.
The answer is because he was not aware of the proceedings. My vendor was not aware of this. And his vendor was the original partner. The proceedings were done against the dead person. So possession was with me till date. At any time, 10-6 proceedings was not done. And also the Honorable Single Judge has specifically stated that possession was never taken and the possession was with us. So the counter is silent in respect of the possession. When possession was not taken and possession is with me, Your Lordship,
that is not your case, Mr. Supposing if you would have come up with the case that possession has not been taken and therefore under the repeal act the proceeding abate, that is understandable. This is not the case.
No, it was my case.
Because you are challenging the this thing for order passed under section 34.
That was not the case and one of the ground was also possession was not taken. That was dead. Your Lordship, that was also one of the ground. That was also one of the ground that the possession was not taken. Possession was with me and the Honorable Court has also dealt, Your Lordship. Their specific assertion that possession of the land was not taken by the government remained unanswered. Your Lordship, page number 185, last, Your Lordship, 4 lines. So my ground was possession was not taken. I am in the possession of the property. Now, when Your Lordship, in the writ petition, I specifically claimed, when I want to go for a permission, they have said that no, there are something proceedings are behind that. So we are not going to give a permission. Then I have approached the authorities, Your Lordship, in the writ petition, I have specifically stated, Your Lordship. Page number 9. Page number 9, Your Lordship, in my writ petition, permit me to read it, just I take 2 minutes. It is respectable that to the petitioner's knowledge, the said notices were not serving in the original owners. Thereafter, the first respondent appeared to pass the revised order for declaring the original deed to hold excess land in various included. No meaningful inquiry was conducted by the first respondent prior to passing the said order. The first respondent has not issued notices to interested parties and did not properly ascertain the nature of land and see whether land was computed as well. In fact, the petition title of the petition in respect of whom the compensation was made for the land in subject was one Mr. Ghulam Ahmed, who passed away more than 5 years back. The order also denotes that Mr. Ghulam never is the first respondent holding of the dead person even without issuing notice to his LR, who in case can do it, have heavy right over the property asset and will transfer. Purporting to act on this basis, the first respondent has conducted further proceedings by passing orders under section 10.1, 10.3, 10.5. All these orders and proceedings were only conducted and maintained against the original owner who ceased to be the owners of the property. The Act and the rules require that notice must be served on any person having any right or claim in the property. Doing violence to this requirement, the first respondent routinely passed various. The second petitioner came to learn about the said orders from several well-wishers that such ex parte proceedings were being conducted when they changed upon the proceedings of the first. Immediately, the deponent approached the public officer and requested for issuance of various orders in written. On 28/9, the public information officer under ULC Act by letter is important. No section 10 subclass 6 proceedings were enclosed or attached despite the petitioners were informed that no section order. Thereafter, the petitioner present a full settlement. ULC present as per section 10.6 proceedings were not taken to the knowledge of the petitioner. The petitioner were the bona fide impression that all the proceedings would lapse. Well, Your Lordship. Para 21. It is respectably submitted that no possession of the property was taken over at any point of time. The petitioners are in possession of the property even today. The Panchanama conducted orders are cleverly brought up by nominal and shame manner by defending the rights of the proceedings. As the entire proceedings were done behind the back of stand, the first.
Yes.
From preparation of section 8 was orderly are entirely illegal and contrary to the provision of the Act 12. So our plea was, Your Lordship, under the repeal act. Since the repeal act, no appeal would lie against the petition consent. So, Your Lordship, our case before the Honorable Court, we are in possession of said property. And We are in the, after repealing, before repealing act, no position was taken from us. So we are in the position of the property, we are not aware of the anything proceeding which we have done behind of fact. After coming to know, we have approached this honorable court. So one of the important ground is your worship, two grounds I am raising. First is no notice was issued to them. And possession was not taken before us. The locus is, as the possession was not taken and we are in the position of the property today, the locus still be there is my humble submission before this honorable court. And rule subclass 5 subclass to specifically says your lordship, notice has to be issued to all the persons, all the interested persons. In this case, no notice has been issued to the interested person. Only notice has been issued to one Navbharat Corporation, which has also the honorable single judge has dealt with this and specifically said that possession has not been taken. So before the repeal act, the counter is also silent.
Thank you.
Just I want to
Yes.
rely on some judgment. I will.
Yes. What judgment?
Para 6 your
Para 6.
as
Yes.
5 your lordship. 5 to rules. Persons aggrieved.
Hmm?
A reading of the above rule provide that
This is person aggrieved
yes, persons aggrieved.
under
as
rule
per
5.2.
5, it's a mandate that notice has to be issued to all the interested persons. In this case, no notice have been issued to the interested persons. My first submission is your lordship in that case, your lordship. No notice has been issued to my vendor or anything. So I rely on this judgment. In respect of their submission is in respect of second point. After that we have purchased. So we are in the position of that property to a registered sale deed, and once a sale deed has been done, it's a public document. They are aware of it, and mutation proceedings have been also done in our favor. So when it's a public document, your lordship, the Supreme Court of law laid down by it that they are aware of it. Your lordship, and the authority should be aware of it. And the honorable single judge has been also specified that the way these proceedings have been conducted by the state, who are the custodian of the document.
Huh?
Pleading application.
Yes. Which IE?
I have one of 2019, but limited,
One.
so because I'm also claiming to
So
the.
he has also, you have purchased from him.
Yes.
Huh? Sale deed
Whether he
dated.
stands blood, I will stand before your
A
lord.
sale deed dated.
Blood, mine is 2012.
Dated. Dated.
March 2013.
All right. So on that basis, you are seeking impleadment, right? 1 of 21. Who has filed?
No, 2019. I filed.
1 of 19. You are claiming on the basis of sale deed. So therefore, this sale deed, right?
To my submission, your lordship is that firstly for exercising section 34 blood after 7 land years, a notice must be, the affected party must be put in notice. In this case, blood before passing GO number 580, Milad, for setting aside the orders of earlier.
All right, we will hear you, provided your IA is allowed. Yes. Next, to 1 of 21.
Another implead petition, right?
Then 2 of 1 of 23. 2110. No, impleadment. Mr. Ram, which IA you will?
2 of 2023 and by
2 of 23.
yes, my lord.
When have you purchased?
Not purchased, my lord. I am a protected tenant. My lord. Protected tenant.
Protected tenant.
Yes, my lord. This 38E also, my lord, issued, my lord. 38E certificate is also given.
No, but so what is it?
Extent of time, my lord, that not covered, my lord.
You for You take the recourse to the remedy. This is state government's appeal. We are examining single judge's order. Scope is confined only to that. That's what in the garb of Mr. Please, we told you in the beginning also, we cannot enlarge the scope of this appeal and adjudicate whether or not you are protected tenant, whether you are entitled to possession, now whether title should be conferred. Do it, whatever.
My lord, UNC proceedings will not come our way, my lord.
Nothing will come. You challenge the UNC proceeding, then what were you doing for such a long time? You should have challenged it, right? Any other yes? 1 of 23, anybody?
Also.
1 of 23 also you are a protected tenant,
Protected
right?
tenant. From protected tenant, we are claiming it.
We will dispose it off with the liberty to take recourse to remedy available to you under the law. This scope is only confined to examining the validity. Please appreciate. Yes, madam, right.
My application for this, it was ordered on 114
Which case?
in the present state rate of fee.
1438.
It's on 22/1/2014. My application then WAN number 37.
22/1 22/1 2014.
Yes. And even prior to my getting impleted, we filed application for regularization.
Sufficient cause to implead. Respond number 3. What is it? Who are you?
I'll tell you. Just give me 2 minutes. Now, the whole extent is about 249 acres. This 249 acres of land belong to 20 individuals. These people have filed the declaration, not one. 249 persons have filed declaration. They were held to be within the ceiling limit. But then subsequent events, the learned government.
No, we are concerned with what land here? 2.28 and 2 acres.
That's no.
Of survey number 574, 575 and 2.30, 564.
Subject matter.
This is the subject matter, 6 acres. Read the prayer, Mr. Petition. This only pertains to not 200 acres, only this.
No, my concern is only this. We have paid money.
You take recourse to the remedy available.
We paid monies to the government for regularization. Government accepted the amount. We are in push.
There is nothing. We are not, as we told you.
Because I also filed 2 separate appeals with leave to connect to this writ appeal.
You just listen to the order which was being passed. Then perhaps we can hear you.
Very
If it's required. Correct. Yes. Yes, madam. Oh, yes.
7th March 2011. 7th March 2011.
7th March 2011. In view of judgment, in view of order passed by us today in WA number 14, for the reasons assigned by us. What do you say?
Yes, Lord.
We have already passed an order, right? This sale, your sale is subsequent.
Lord, my sale, Lord, there are 3 writ petitioners, Lord, who are respondents 1, 2, 3, Lord. So, second and third respondents in the appeal, Lord, they purchased the property in 1989, Lord. After that, Lord, it was an unregistered sale deed. It was regularized in 1996 under the Patdar Passbooks Act, and their names were mutated. Passbooks were issued.
No, but learned single judge allowed it on the
ground of the earlier order. Not as the merits of the matter means.
Lord, merits again, Lord, your lordships have observed.
Item 1 merit 25. We will see. Let us see what is the order.
Very well.
So in any case, since your claim has not been item 25, so your claim has not been examined on merits, right? Let's see what is the order.
Yes.
Serial number 25, WA 28 of 2014.
Page 6 is the order. Page 6 is
You
the
read more.
Yes, ma'am. Land Council for the petition submits that during the pendency of the writ petition, GOMS 580 dated 4/5/2005 was struck down by this court in Heritage Estates so and so. It is therefore submitted that GOMS number 580 dated 4/5/2005 was struck down by the The petitioners are entitled to retain their lands and no proceedings under ULCR.
No, Mr. But in this case, you can't succeed on this ground. He had locus, right? He had purchased.
But the writ was not addressed on merits, only basing on the earlier.
Mr. Then in that case, we will remit the matter, right?
Very well, my lord.
Learned single judge.
Yes, very well, my lord.
This intra-court appeal has been filed. Yes.
I'm obliged.
Next. Item 16.
This is the writ petition, my lord.
Ah.
Now counter has been filed contradicting the governments of the writ petition.
Ah.
Not the writ.
My lord,
What is the rate petition about?
I seek time in this matter, my lord, because the bundle is not raised as of my office.
Hey, what, madam? It's in the list, right? For quite some time. This week, at least, it has been in the list.
We could not raise the bundle, my lord, a short adjournment.
Yeah, you have not filed.
Yes.
I couldn't raise the bundle, my lord. I do not know the particulars. If your lordship may accommodate
Next
me
week.
by 1 week.
Next week, madam. Mark the present. Seven. So, Mr. No orders are required on your IA.
The only thing is, there are two more appeals for item 26 and 27. The same order will not now passed by my lords can be made in those two cases also, because those inspections were filed by the LRs of the original declarants.
Which 26 and
27.
Who appears in 26? 1 minute, 26 and 27?
You know, I sail with the state in both those two cases. I filed an appeal questioning the order of the Justice Narasimha Reddy on the ground that just we were not heard by the Justice.
So no orders are necessary now on this.
No, it has to be remitted back to the judge because we were not heard. Same like
Not
item
heard?
25.
No, not heard means like
We are not parties there. The learned judge simply followed the earlier learned judge's order.
so same order, right? Yes, Mr. You are appearing. So that order has been set aside, and since matter has not been examined on merits, so he has filed. Twenty-seven. 26 we can decide, right? 26. Yes. So against which order, Mr. 26? This write down 26. This intra-court appeal has been filed. No. So state may not have, but they are claiming some their right of audience. What this? No.
Not rejected, not rejected.
4th October 30. The item, Mr. 27, get 27. Oh, 26 also. Are Mr. 26 you.
No, that is like, that order, my lord, is that page number 48 of the paper book.
Don't type this 26, right? 26 you get 26. WP WA 1120. Not there. Not scan. Give. Order sheet, madam. Which order? Which order, Mr. 4th October.
That is previous proceedings unconnected with this.
1 minute. No, but 4th October 2013.
This is a 14 writ appeal. He is talking about a 13 writ appeal order.
Yes. Oh, Mr. There's some confusion, right? See.
Please see page
No, please see this. See, we don't think, please see, go through. No, please see. Please see the order sheet. I mean, there's, like he's correct in this, you are referring to 2013 order, appeal is of 2014. If leave to file appeal would have been dismissed, his appeal would have also been dismissed.
But please see the order, my lord, of the said date, that is 4th October. The division bench of this honorable court presided, headed by the learned chief justice, said, admittedly, the appellant did not prefer appeal against the said reported judgment, that is of Justice Narasimha Reddy, which was relied upon. And he asked us to implead in the writ appeal and then challenge that. We impleaded and challenged that order. Page 50 of my paper book in this item number 26.
See, the item number 26, you see, the common order only places reliance on heritage estate and holdings. It has not been examined on merits. If you see this writ appeal, like the order is common, what his contention is, Mr. No. What we have done is, see, the main order was passed in that heritage estate item 19. That order we have just now, you have seen that we have set aside. Now, other connected matters, the learned single judge, instead of examining, has followed. So therefore, they are being sent back. So item 26 is correct, that this order has to be passed, because again, this is an order only.
Item 26 arises out of writ petition WP number
12936.
12936. ఎప్పుడు
Venkateshwar Plot Owners Association. Yes, different. Different. No, same, sorry. Yes, correct. Venkateshwar Plot Owners Association, right?
Yes. Kindly see this order of the division bench.
No, what is
this? Is Honorable Chief Justice, Justice Kalyan, Jyoti Sen, and Justice Bano. Please read the order, my lord.
What?
Unnumbered paragraph 3. Admittedly, the appellant did not prefer appeal against the aforesaid judgment, that is the main judgment, which was relied upon by the learned judge. Learned counsel for the appellant submitted that an appeal has been preferred by the state and reported so and so. We are of the view that unless and until it has been done, the appellant is allowed to be impleaded as party respondent to the pending appeal. The appellant cannot challenge the impugned order at present. Therefore, we are not inclined to grant leave to prefer appeals against the impugned order of the single judge. Accordingly, so and so. He gave us, after this, we filed implead WA number 3771 of 13, which was ordered on 22/1/14, and thereafter we questioned those things.
This, what happens, right?
We filed in 1438 as directed by the division bench.
No, probably what the division bench wanted to say. And at that point of time, in the absence of any impediment, like that's why they filed an application for leave, right? No, correct. No, we are trying to understand the observation made. We are of the view that until and unless this has been done and appellant is allowed, it cannot challenge the impugned order. Therefore, so what he says is that after his application for impediment was allowed in that writ appeal preferred by the state. Thereafter, he is filed.
Yes.
No, leave petitions in that writ appeal previous, because what the division bench said, as we understand, subject to what you say, his submission is. Correct. See, he obviously he was not a party in those writ petitions, right? That's why he filed an application seeking leave to appeal. The division bench of this court took a view that until unless he is given the liberty to be impleaded in the appeal by the state, he cannot challenge this order.
While implead in the appeal filed by the state which was just allowed. Please see, admittedly, the appellant did not prefer appeal against the aforesaid judgment, that is Heritage Estate. And then which was relied upon by the learned single judge. Then it says, whereas counsel for the appellant submits that an appeal has been preferred by the state against the aforesaid judgment, and the client will take necessary steps for impleadment as the party respondent. But we impleaded and filed writ appeals now, afresh.
He cannot tell it to judgment. State not is what was left to be is that's what is the game is something. Whether they are not coming, I don't know. Anyway, the is already set up with not. So nothing for them.
That judgment, that's what we initially, Mr. The judgment has been set aside. Now, what is this same thing you have challenged, right? So why we should remit?
My rights have not been at it is like this. Justice Narasimha Reddy's order was under challenge in a writ appeal before my lords.
Yes.
My lords were pleased to allow the writ petition on the grounds that on the grounds mentioned by my learned judges. So far as Justice Nagarjun Reddy is concerned, when the matters came up before him, learned judge simply followed without going into the merits of the matter. And therefore,
that's why, Mr.
That's the reason we filed.
We will keep all the contentions open, Mr. You can argue if you are respondent in that. No, but he is claiming a right, right? He was
not a party.
No, what happens to the leave petition here?
It has to be granted for the reason that after the earlier in 2013 order, we filed an application for impleading. That impleading application was allowed on 22/114 in 1438, and then we filed these applications.
No, but the subject matter of this, your writ petition is different than the one in this thing, whatever in the main order heritage state. Ah. Ah.
Third party wants to file a appeal. Third party along with third party. Giving liberty, each other, each other.
One.
But please read that order once again. Will not permit me to read. I'll read now, my lord. Obviously, the petitioner appellant was not a party to the writ petitions. It appears from the impugned order that the single judge has not decided anything new following the decided in heritage building. Admittedly, the appellant did not prefer an appeal against the aforementioned reported judgment, that is Justice Narasimha Reddy, which was relied upon by the learned single judge. The learned counsel for the appellant submits that an appeal has been preferred by the state and the aforesaid reported judgment, and the client will take necessary steps for its implement as respondent. We are of the view that unless and until this has been done, the appellant is allowed to be impleaded as a party respondent in the pending writ appeal. The appellant cannot challenge the impugned order at present.
Mr. One thing, like one way of putting it can be until unless it is done, he can't challenge. And if it is done, he can. Something like I will.
There is nothing around for the we have to be order the other rate of they not allowed because of the main from the local.
No, his implete petition in that writ appeal has been allowed. No, but he has succeeded in that. No, suppose like,
Fresh writ appeals with leaves are there.
It's this one, fresh appeal. This one, item 26.
26 and 27.
27. 2014. After this order, right? See, this common order was passed when? 13. Thereafter. Thereafter, they filed fresh appeals.
Before the agreement.
No. In the writ appeal preferred by the state, their impleadment was allowed in some long back. 14 itself. So after allowing out the application for impleadment, they filed these two appeals in terms of the order. Yes.
Fresh writ appeals.
That's why. So therefore, the order has to, the matter has to go back before learned single judge. Because see, the order is, please see, nothing, one paragraph, only heritage, that has been set aside. And no other contention. That's why we are remanding.
So in that stage, you can not be fine with the only private parents. Because my secretary, property of the officer and government etc. have been allowed in the state, not guidance.
No, but that order is now. All you will argue afresh, whatever challenge. No. What has happened? See, the original order, that heritage state, that has been set aside on the ground of locus. Now, other petition, the learned single judge, instead of examining, has only relied on heritage. So therefore, and it has not examined any other contention. So we have no option but to remand the matter, because see, we can decide also in writ appeal, but you will, in the process, parties will lose the right of appeal.
All the other questions,
They will go back. Yes, we will pass such an order in all the cases. Yes, that's what we are saying.
I'm obliged.
Yes, madam. Where is he gone? That person. So which order we dictated? Say the same order is come.
Yes.
26. What order? Read. Yes. So 26, 27. Yes. Call item 19. Yes.
Well, item 17 also.
Seven.
These have been tagged down, before, in fact, learner single age matters for heard. Because of the 1438 writ appeal is pending, this has been tagged down. In fact, it was abated before the learner single age.
Which?
Item 17.
1 minute. 17 or 21277.
Yes, ma'am.
Where is 21277, Mister? Not there. Not scanned. What is this?
Well, this is arising under Urban Land Ceiling Act, but we have purchased, prior to that, what is the revised order
So
passed.
it should go before learning single age. Let the item number 9. What? No, not 9. 17. Let the writ petition be listed. One 438, right?
Right. Please.
WP 18. Yes, madam, get the copy 18. It's not scanned. Yeah, not scanned.
Number 28. Number 28.
Huh.
But it's a public interest.
Huh?
The public interest litigation, fine. Wherein I filed an application to implead a lordship because I am the owner of the property and my application IA number 2 is pending a lordship. The other number that may be ordered under
Huh? Now, what is it about? We are not going to declare your title here in PIL, right? What is the, you should, or wait, you are only an impleading applicant, we will deal. Nobody is appearing for the petitioner. Relief rate, rate inaction not protecting government land.
not may submit on aspect. The person who filed this writ petition, he himself not contesting some of the petitioners not were encroached onto the government the property which I claimed. And he has interest on the property.
We had that removal of encroachment order. Get that order. We cannot decide, Mr. He is an encroacher, you are an encroacher. All this in a writ petition cannot be decided. We will show you an order which balances equities. The action will be taken by the Tehsildar. Concerned Tehsildar after hearing all of you.
I
1 minute.
Last mechanic. Item number 90.
No, you first see the order and argue. Because that's a complete solution to this situation and it's not the job of the court to find out who is an encroacher, who is what. See that this all petitions have been tagged with urban land ceiling matter.
Yes, that's the same property.
But see what is that encroachment, madam, you don't have that order, encroachment. So you are saying that it's your own land, you have purchased it by sale deed and all that.
But
Which land you have purchased?
in fact,
Which land? Which land have you purchased?
That land is not survey number 80.
Huh?
Survey number 13.
30.
582 and 583.
Huh?
582 and 583 of Palwal village.
How much land?
And it's about 40 acres of land.
You have purchased the entire land. How many? 15 and 12, 27.38 guntas. And 28. You should know, Mr. or everything you are claiming. How much of land have you purchased? What is the sale deed?
I filed all the documents, Lordship. I'll.
Tell us, when have you purchased? How much of land?
That initial note from the declarant, Lord, I have entered into a sale agreement, Lord. When my sale agreement was, they were not performed, Lord, I filed a suit before the trial court. And suit has been decreed, Lordship. And by virtue of a decree, Lord, the honorable court has executed a sale deed in my favor.
How much? We are asking about the date of sale deed. How much of land?
That is a three extents, Lord. The 3 extents are, Lord, each. Lord, in survey number 582, about 6 acres of land, Lord. In survey number.
Huh? No, separate order also. Petition has been disposed of for filing compliance report also. You have typed, madam. Sadi had sent it from. No, this is an interim order. Apart from that, there is a separate. We should, what you people do, madam, don't. This is an interim order. In a public interest litigation, one, two, three, four, five, like these are the directions.
In fact, my lord, this writ petition, this bill is my lord, connected to item number 19, my lord, which is already remanded to the land single judgment.
A removal of encroachment after hearing parties. Who is the competent authority to find out, ascertain the nature of land, mister? Huh? Huh? Who is the authority? District. Call Rahul. Rahul. Ah. So he will carry out the survey, mister. The collector will carry out the survey, will give an opportunity of hearing to you as well as to this thing, and thereafter take an action in accordance with law. Right? It is open for you to produce all documents that you are the owner. Correct? This is an innocuous order.
May I submit?
You understand, right, what we are asking? We will ask the collector or the concerned collector to examine the grievance of the petitioner. The collector shall ascertain the nature of land, shall give this thing, shall give notice to you as well as to petitioners and decide the nature of land, what is it. The survey will be carried out in your presence. If it is found to be a government land, then the action will be taken for removal of encroachment in accordance with after hearing you. We cannot in this writ petition decide and declare your title. This is not a civil court. If you are the owner and if somebody is challenging your title, go and file a suit. In a public interest litigation, this is outside the scope. The Supreme Court has said that the court in under Article 226 cannot declare the title of any party. So by impleading, don't expect us to do that. We will hold that you have purchased the land and therefore a declaration in your favor is granted.
My only
We have understood. You have not even told us the date of sale deed. What can be done?
My one allotment. Yes, is kindly minute. I'm not asking to declare my title, Lord. But I am not asking to declare my title, Lord. Not with regard to my right, Lord.
This is the removal of encroachment.
But my only endeavor to this Lord. The person who filed this bill, Lord, he is having a vested interest on the same property. And that he is appearing some of the parties who have encroached onto some portion of the property and who filed the present bill, Millard, saying that government should protect that particular property. He himself is an encroacher. That's no, that point I would like
No, so therefore no inquiry should be made whether the government can.
In fact, Millard, when
we are passing in it, that itself shows that you are an encroacher, right?
No, Millard.
You are resisting the prayer which we are saying that the collector will give you an opportunity of hearing, thereafter shall carry out the survey. If it's found to be government land, then he will take an action for how are you aggrieved. According to you, you have purchased this land by sale deed, you produce the sale deed before him. How can the collector cannot sit over the sale deed and say, no, no, it is my land?
Before that, no, one separate fact. But item number 19 is
We are talking about this PIL.
Item number 19, Lord, is the same implead petitioner has filed writ petition item number 19 before the Honorable Court. Back to the appeal lordship that the Honorable Court already remanded the matter not for the single judge for fresh adjudication. But agreed by the ULC order, the implead petitioner also filed a writ petition that was just now your lordships have remanded the matter for fresh adjudication. And so far as my rights are concerned. Now I am only before the Honorable Court not saying the person who filed this the Bill Miller, who is also not representing some some encroachers, he is representing
Maybe an encroacher. It has the issue. This is the petitioner loses this thing. The issue with his protection of public land from encroachment. If you are not an encroacher, you should be happy. What is the hitch in producing this LDD before the collector? That means you are an encroacher. You don't want an action by trying to say.
But all my documents, all my bundle of documents are placed before the Honorable.
So then, what is the problem? Like we are passing an order, it is subject to 136 appeal before Supreme Court, right?
No, I have only implead petition lordship. I am not the petitioner.
No, you can, if you are aggrieved by our order, you can challenge that. That's what we are saying. We are passing an order.
My back this Honorable Court, my implead petition is not entertainable before this Honorable Court.
Yeah.
My implead petition is not entertainable before this Honorable Court. I am permitted to withdraw my implead petition. So my only endeavor before this. My only endeavor before this Honorable Court is.
You are not understanding the order which we are going to pass, Mister. It is an innocuous order which we will direct the collector to carry out the survey of the land. He will give an opportunity of hearing to petitioner as well as to you. You can produce all documents of title, whatever sale deed you have filed before collector. And if the collector is satisfied that this land is in your possession or anybody else's possession, is not a public land, is not a this thing government land, he will not take any action. If it is found that it's a government land, then he will take action for removal of encroachment in accordance with law. That is what we are saying. It's a standard order which we pass, but unfortunately our staff is unable to get it. This is the order which we have passed consistently in all this thing. This is an innocuous order. Any order is passed, you can challenge it. Yes. What? I will tell you now. A separate order has also been passed, madam. I will tell you now. I can't use the phone here like the advocates. I will tell you, she has sent it on WhatsApp, email. How you people don't know?
I am for the implead petition order.
Whatever. In this petition.
Number 19, my lord, wherein
Huh? Allowed, whatever. No, he has been heard, right? Yes.
May I submit? And in item number 19, my lord, this sample court remanded the matter wherein the included petition is the party, my lord, wherein the land single judge passed an intermodern law restraining the state government not to interfere with the position of action. My humble submission is, my lord, item number 19 of this sample matter, wherein, my lord,
There is no remand, mister. There is no remand. It's a rate petition. It should go before learned single judge.
in that, my lord, that in intermodern, my lord, restraining the state government authorities not to interfere in lordship. But that need to be ascertained, that need to be adjudicated by the land single judgment.
You are there to assist, no? How effectively you have assisted us. You don't know this sale deed executed in your favor. What else, mister? Really amazing. The level of assistance we are amazed given to us. You don't know. And all this proceeding, we thought that after live streaming, you should be more like you will be concerned about your performance. Your client can watch. You are unable to tell that when sale deed is executed in your favor. We have recorded in the order that you are unable to tell when the sale deed is executed. What is this? Strange. But we can't say anything further. We have passed an order.
My only submission, single judge.
Now this order is subject to Article 136 SLP. File an appeal if you are aggrieved. Right? We can't do anything. We have passed an order. When we are now sitting here to convince you that you should agree to this, nothing. We have passed an order. Challenge it. Not happy, go. Yes. This thing lunch motion has come. Why? They have not filed. You have not filed the petition. So we will take it 5 minutes later. Next 29.
29, Lord. Item 29, Lord, I am for the.
Yes.
Lord, the appeal. State appeal, Lordship.
Mandamus.
That issue is different, Lordship.
Requesting taking further action.
This may be remanded to the land single judge. This is not pertaining to this appeal, Lordship. It has it. This particular petition is not pertaining to.
Not pertaining to that.
We have understood, Mr. This what he is saying, remand and all that. You don't know anything, right? We will find out. Thank you. Please sit down. What is the prayer made? It's a writ petition. How can it be remanded to learned single judge? This is a writ petition itself. This is not a writ appeal. There is no question of remand. What, Mr. Horrible, right? Horrible. Thank you for your assistance. That's all. We are full of gratitude for you. Full of gratitude. We will have to appoint an amicus curiae. Mr. You take his file. Mr. Take his file and see what is it.
This writ petition was tracked to the writ appeal in item number 15, Lordship. And this writ petition was tracked to item number 15, Lordship. It's altogether a different subject, Lordship. This is not my
heard by single judge.
Just heard by the single judge.
That he should say. He is saying remand. Where is the question of remand?
Detached. I'm so sorry. Retagged.
Has to be detagged, not the.
Retagged.
Detagged, not has been tagged on the written bill item number 15. Now that it has been.
Let the writ petition be listed. Oh,
Yes.
huh? Declare. Same order, single judge before. Hmm. Yes, Mr.
Lordship, we have applied for the MBBS C category, C category, Your Lordship, but the respondent number 2 rejecting for the web options, Your Lordship.
Recently, your lordship passed orders in 29108 of 23, wherein the university has conducted all phases of posting. There is no further round of posting. Without any stay vacation.
Which order passed?
29108 of 22.
29108. Page 33.
Well, it's not filed.
Huh?
That order copy was not filed.
Copy is not filed by the petitioner.
Not fine. This is the order 29.
In 39, Lordship, page number 39.
Hey, you said covered, right? You said in the medical admission covered.
Yes, Your Lordship. We have granted interim order.
What is the case? We have not read it, obviously. You can't behave like him. That you don't know the sale deed and this thing.
We have granted interim orders pertaining to PG admissions, Your Lordship. Similar circumstances like that.
Hey, what is the same?
We have applied for the.
Please understand, on your request, we have taken it today. We have not read it. You cannot rely upon us that the court will do everything. You also don't know what is his case.
In fact, my lord, the petitioner has got registered for B category registrations.
Action of not considering for.
Management quota, various course.
Hey, what is this, mister? This is not most unfair thing you can do. Asking us to take up the cases and then not knowing what is the petition about. You don't know.
Lordship, kindly will file the recent order copy, Lordship. Kindly post
No,
this
no.
matter Monday, Lordship.
No. You are negotiator of the case. That means you are telling us that for all times to come, we should not rely on you. Right? So when we, no, that's how it is, Mr. Is it being fair to the court that you said that the case be listed today? We have listed it today. Now you are seeking an adjournment. It will not be adjourned in no circumstances. It is on your request that we are departing from this. We thought it's an urgent matter. This is what it is, Mr. Unfortunate. What is it, Mr.? What are you saying? You don't know.
Well, in fact, the petitioner got registered for.
Call Mr. Rao. What can be done? You also don't know. Sailing in the same boat.
My lord, in fact, my lord, there will be no more further round of posting for various posts, my lord. So now the petition want for participate in stay vacancy round, my lord. As per my instruction, my lord, there are no further round of postings for various posts. If at all any seats are vacant, my lord, that will be filled up by the concerned colleges, my lord.
So why he wants to participate?
Because, my lord,
Why he did not participate?
all round of costings have been completed, my lord. There is no. The lordship may kindly see, page number 12, my lord.
One.
Page number 12, my lord.
See, this is what it is. Counsel. See, the petitioner has engaged with me. Petitioner should be here to see what the council is doing, right? You don't know what is the case. What can be the worst situation? Yes, there no counseling.
The Lordship, may kindly see page number 32, my lord.
You asked Mr. Rao to appear, Mr. Better. You also don't know anything. Fine.
The NCC has issued this notification, my lord. Lordship, may kindly pass on.
Yes.
Kindly pass on.
No, what is it? Page 32.
Page 32, my lord. This is the notification issued, my lord, directing the state authorities to conduct counseling, my lord, in respect of seats available in the quota. Pursuant of this notification, my lord, the university is taking steps for conducting CQ convener quota counseling, my lord.
Communal quota?
Convener quota counseling, my lord. But in so far as
I heard communal quota.
convener quota, my lord.
Convener.
So far as management quota counseling is there, my lord, there are no. The university is not conducting any management quota counseling, my lord. So the petitioner is not entitled to.
All right. Yes. Heard on the question of admission in this writ petition.
Similar matter.
Dismissed. The same order. 3 also same. So why you are not deliberately telling the facts, right? Because this is unfair, Mr. Pradeep. Unfair.
Lordship, there is a.
The cases may be allowed, may be dismissed, right? But you will be practicing in this law. We know your conduct, right? I know that you are capable of telling facts, you are deliberately not telling. This is not fair. You thought that the court will adjourn the case. Why did you invite the trouble in the first place by asking? We were saying that you said that today itself medical admission.
There is a
And not telling the facts. Not fair. Don't have this sort of an approach. Yes. This is, yes. This you do it like this. Collector.
With your lordship.
Instead of Tehsildar collector, you keep that, give a copy to her also.
Lordship.
Huh? Why
Lordship,
you should keep
With your lordship's name. And item number 37 can be closed.
37?
Yes.
What?
It is, in fact, it is a matter where the petitioners have questioned the eviction order issued by the municipality. The subsequent developments is that the government intends to regularize the lands allotted to the petitioners. That I have filed in additional material papers and also amended.
Orders have been issued. Orders have been issued below in page 4, IA. Seeking regularization.
Orders have been passed?
Yes, memo has been issued, Lord, taking a decision for regularization of the position.
Then it does not survive, right?
Yes.
Now, in view of that, it can be closed. I have filed the
In view of
additional material
this-
papers.
To appear for fourth respondent in this case. But my instructions are that the municipality is regularizing the shops, not by the government.
That's what he's saying.
It's a municipal property, municipal will regularize the shop, not by the government.
No, but he does not want to prosecute the petition. Can you present him that no, he should file, he should continue to fight?
I'm sorry, Lord, I never said that I did. I'm not tends to continue the petition. No.
Then it will be hard.
In view of the Lord, yes. So please, I will argue the matter. It's
No, you said it can be closed, so there would be a pass and order.
It can be disposed of in terms of the memo issued by the government. Memo issued by the government.
So then we will have to write the facts, right?
Memo. Lordship may kindly refer. Because I filed it along with this memo.
It is.
Yes. Because
And any other terms. No, now you don't give one by one. Thereafter you will say another document I filed.
These two documents go together because in pursuance of that memo only, the municipality has not.
So the government memo. Like putting a premium on an encroacher. All along he has encroached, the property is granted for a song. 15,000 rupees is granted government land. Who, you are a trustee in respect of a public property. How can you like just give date to dishonest people like him? No, quashed. Petition is disposed of.
Lordship, Paul request your lordship.
What is amendment?
Lordship,
Yeah, nothing. The petition itself is IA interlocutory are disposed of. That's always there. Use write it. IA, this thing are disposed of. Always write that standard.
lordship permitted to withdraw my.
No. You should always remember, right? That's why we are not permitting withdrawal. Next week. Next week. Where's the order?
The contempt matters. May I make a mention, Madam?
You extra copy you don't have.
May I make a mention? Contempt case next Friday, Madam. Before your lordships. When contempt case is required to be listed, there's to be listed before your lordships. Next Friday, Madam.
When?
Next week.
Single bench.
Single bench.
Yes, next Friday. Yes.
Obliged. Take a mention, Madam.
May I make?
7. Yes.
Appointment of arbitration.
Next Friday. 78 to 80. Issue notice. Call madam. Call. 78, 79, 80 issue notice. Personal notice, proof of service. List immediately after respondents are served. Yes.
Appear for the petitioner.
Yes.
Sir, I may seek 1 week's time of filing rejoinder to the counter.
Rejoinder, what is this?
Compliance of the order passed by the commercial court, wherein a garnishee order was passed against the respondent department, directing that he should process an amount of 47 lakhs and 60,000 and deposit the same in the court. My lord, alleging that that order was violated, this contempt was filed.
So what you want to file a?
Rejoinder, my lord. In this case,
how
the
much
tax
time?
have to be. Next week, my lord. Next week I'll file.
Learned counsel for the
May I make
petition.
one respectful submission?
Yes.
Now, my lord, we have stated in the counter that the present respondent, my lord, he was transferred to other place in Kadapa district with effect from 13/6/2023, and a new gentleman, my lord, has assumed charge. And the person who has to implement the order and deposit the amount before the court is some other person. I would share the details of that officer to my learned friend. He can take steps to implead him.
Right.
Because my lord, this being a contempt proceedings, my lord, the person who was in charge at either point of time, my lord,
He will be responsible for the period for which he held office. That's correct.
That's
no, but what about the new person, right? He is also under an obligation.
my humble
You
submission.
don't want, right? His choice. What can
Correct. Let him let him furnish me the details of the other person. Right?
That's what you should do, right? By next date, file an application for impleadment so that this he will accept. We'll ask him to accept notice on behalf of that officer also. But there has to be a formal impleadment, right?
Yes, sir.
Otherwise, who will implement? Supposing there has to be supposing if we come to the conclusion that the contempt has not been purged, then there has to be. There, you understand?
The office has to be held.
You understand, right?
I understood.
Yeah, fine. Yes, what is this appeal?
This is appointment of arbitration, Your Lordship. This. It's copy, maybe.
Yes. So what is it, madam?
This is Vidya Drolia case law. I have referred the last occasion, Your Lordship. The last page. I have
What
given
is it? This.
Seeking for appointment of the arbitrator.
Arbitrator.
The respondent, my lord,
the arbitration.
I have taken an objection that, my lord, the arbitration clause in the list deed does not amount to, my lord, arbitration clause by relation.
This it provides for may or something.
Yes.
Stroke this thing. Which page?
Page number 28, Your Lordship. Page number 28 of arbitration, that application, Your Lordship. And the clause says so, Your Lordship. The
Right.
parties shall resolve the dispute by mutual consultation and deliberation, failing which the matter shall be resolved through arbitrator, civil courts of Hyderabad. They are stating that the clause is not absolute, Your Lordship, and for which they are relied on the reference of the citation, Your Lordship, and in which
judgment?
Jagdish Chandra judgment, my lord.
which is there.
Which citation, Mr.
7.5 SCC, Your Lordship.
My lord,
2007.
5 SCC 719.
On the last occasion, Your Lordship, they took reliance of paragraph number 8, Your Lordship, which states so in paragraph 8. It says that the intention of the parties to enter into an arbitration agreement shall have to be gathered from the terms of the agreement. And in the next, it is being shown, Your Lordship, the arbitration agreement where there is merely a possibility of the parties agreeing to an arbitration in future does not conclude as an absolute agreement. That is what their contention, Your Lordship, and further they relied.
No, so madam, does it not, this agreement, does it not provide for this thing either to go to civil courts of Hyderabad or to arbitration?
Your Lordship.
Not mandatorily. That
Your Lordship
is.
may kindly see the reliance of their judgment, Your Lordship, in column 4, Your Lordship. It is being shown.
4.
Paragraph 9. In 8, last paragraph. In 8, last paragraph. 4. It is stated, Your Lordship, mere use of word arbitration, arbitrator in a clause will not make the arbitration agreement if it requires, contemplates a further fresh consent. That is what it states, Your Lordship. But the paragraph 5, Your Lordship, it may be seen. Para 16 of the partnership deed provides in that reference, Your Lordship, if there is any dispute touching the partnership. 9. It states so, Your Lordship, if there is any dispute touching the partnership arising between the partners, the same shall be mutually decided by the parties or shall be referred to arbitration if the parties so determine. That is the word of that case. In the referral, it is been mentioned, Your Lordship. In the clause had merely said that in the event of dispute arising between the parties, they shall be referred to arbitration. It would have been an arbitrator agreement. If the words it is being so stated shall be referred to arbitration.
Mr. Pragmatically speaking, instead of getting into this dispute and asking the court to decide this thing, pragmatism requires you to not to oppose. I mean, of course, you are entitled to. Otherwise, what will happen? Supposing if I agree with your contention, it goes to Supreme Court. It will take its time. If it is decided, you will not be like a civil suit would be filed. So, I mean, why do you want to prolong I mean, that's, of course, it is for us to decide, we will decide it. But we don't know, we really don't know whether your client has been given proper advice. Fine.
Yes. I have instructions, my lord, to oppose the
arbitration. Yes.
And Your Lordship. And again, it is being stated, Your Lordship, shall be referred to arbitration is an agreement that existence, Your Lordship. It would have been an arbitration agreement, but the clause of the word shall be referred for arbitration in the parties so determined completely changes the complexion of the provision. The expression determine indicates that the parties are required to reach a decision by application.
No, that's correct, madam. What do you, this thing, they shall be resolved through arbitrator or civil court, / means or. That's the problem, this thing.
Your Lordship, even there is a slash before that also, Your Lordship, and that is been resolved the dispute by mutual consultation and deliberation, failing which the matter shall be referred / resolved through arbitrator / civil courts of Hyderabad. It is being stated, Your Lordship, and while
No, so what, I mean, the civil court will resolve the dispute under section 89. That is the argument.
yeah, it is open, Your Lordship. That is not an argument, but the / is there. I'm relying on the citation of Vidya Drolia, Your Lordship, which I have been.
Ah, yes. Which paragraph?
In the last page, Your Lordship, in the last page, 244.5, Your Lordship, the scope of the court to examine the prima facie validity of an arbitration agreement includes only whether the arbitration agreement was in writing, whether the arbitration agreement was contained in exchange of letters and telecommunications. With this aspect, Your Lordship, the arbitration agreement is in writing, and even I have an option of civil courts that for the sake of the argument, if I'm keeping it aside, Your Lordship, the legal notice which is being issued in reply to the legal notice which I have been given, the legal notice which they have given the reply, Your Lordship, which is in page number 57 of the application, Your Lordship. In the page number 57 of the application also, Your Lordship, though they have denied that there is an arbitration clause.
What is, madam, what is your argument with reference to this Vidya Drolia? That court has to look into validity and cannot see anything else.
No, sir, no,
and
Your
therefore, the dispute,
No, Your Lordship. Even in page
please understand, it does not deal with the issue whether an arbitration clause mandatorily requires a reference to arbitrator only.
Yes, Your Lordship.
It's what
in page number
44.5.
In page number 159 may be seen, Your Lordship. 33.33.
33 point.
159, Your Lordship.
Yes.
And even it is seen, Your Lordship, as per the section 8 and 11 arbitration and conciliation, the scope of judicial intervention is only restricted to the situation where the court judicial authority finds that the arbitration agreement does not exist or is null and void. But there exists an arbitration agreement, Your Lordship. It is been clearly stated that the arbitration agreement is, it can be referred to arbitration agreement. It is not can, Your Lordship, it shall be. So there is an agreement of arbitration.
So what is the purpose of then this thing mentioning civil courts in Hyderabad?
That if any criminal cases has been arised out of this agreement, that may be referred to the civil courts. That may be the intention, Your Lordship. I sought instructions from the client, what may be the reason for putting this kind of thing, and they said it is been convinced by the other side to them that it has to be the clause if any criminal cases has been came forward out of this agreement.
Yes.
But as per the Malot, the judgment which I am relaying, it is clear that Malot, even as per the arbitration clause, it says Malot, or arbitration or civil case. The judgment which I am relaying is very clear, Malot, that the arbitration agreement should be specific. So,
where was that the clause has been this thing?
Clause
reproduced this. Para 2 probably. During continuance of partnership dispute, same shall be mutually or shall be rep.
Clearly says Malot, this in the cost of reputation. I just read Malot once again, para number 9. Para 16.
Yes. All right.
Means that it is not an arbitration agreement, but a provision which enables arbitration only if the parties mutually decide after due consideration as to whether a dispute should be referred to the arbitration or not. In effect, the clause requires the consent of parties before the disputes can be referred to arbitration. The main attribute of an arbitration agreement, namely consent and item to refer the disputes to the arbitration, is missing in clause 16. The same Malot here is also missing.
All right. Anything else, madam?
that the negativity that there is no absolute contract is not available, Your Lordship. If parties so require or if parties so determined, and these kind of words are not been mentioned in the arbitration agreement, Your Lordship. It has clearly stated, refer to the arbitrator / to the civil court, which does not come in that ambit, Your Lordship.
All right. Yes. Dispute. 83. Yes.
For the
Mr.
respondent.
What is it?
Uh, is it is the arbitration clause has been invoked against the personal guarantors method. Personal guarantor. Whereas it is already resolved. It has gone to IBC. I mean, under IBC, they have filed Section 7 application in NCLT.
Who appears for the petitioner?
I am not. I don't know.
K. Ravi Mahendra.
No, it is clearly resolved already. Last occasion, he seek time for going through the counter last occasion.
What resolved?
In the resolution plan which I filed in the counter, my lord, it is already resolved. In the resolution plan, which is filed in the NCLT.
What has been resolved?
This issue is resolved. I'll take you through page number 222 of counter, my lord. 222. I'll read out. My lord, sir.
All right, we'll hear you next week. None for the petitioner, so and so for.
I appear for the applicant, that's.
What is condone issue delay? All right, delay condone. Yes.
That's the arbitration clause is at page 37, arising out
37.
of a development agreement.
37.
Page 37, article 28. Arising out of a development agreement.
Clause
28 minutes.
20. 28. Development agreement.
Development agreement minutes.
Yes. What is?
We have done the objection. We have done the objection to the appointment.
Don't have any objection. No. Yes. So what is the dispute nature of, and what is how much is the claim?
Quantum is we have executed after the development agreement, we have made some constructions. To that extent, they have also entered, and the quantum is 9.6 crores. In which part payment they agreed to 4.5 crores, and that's all, my lord. The quantum to this extent is 9.6 crores.
Yes. What do you say? This petition under section 11 with
For the adoptions.
85 to 91, today we filed our counters, my lord. From 85 to 91, we have filed our counters today.
Just now, a copy of counters has been given to your lordship. May accommodate me next week?
Next week.
In case.
Learn it comes. Up to 91. Yes.
91.
91. Yes.
My lord, I beg to represent, my lord.
And for the respondents, 1 to 4.
We have been served with counter yesterday, my lord. We find a reply, my lord.
Arey, what reply?
My lord, they have challenged our locus and also they have challenged with respect. My lord,
What is your defense, Mr.? No arbitration clause.
My lords, we have raised two defenses, my lords. One is that insufficient stamp duty, and second is the locus, my lords, because they have a their
Latest statement of Supreme Court.
yes, my lords, and
Where is that? It has to be insufficiently stamped. It has to be impounded.
yes, my lords.
Go to the collector of stamps, pay duty.
Furthermore, my lords, they are a partnership firm, and it has already been dissolved according to them out.
Oh.
my lord.
When it is a dissolved, my lords, they cannot invoke an arbitration clause.
Next week. Learn it comes to this petition under section.
And to the response.
Yes.
May it please, no. I'm for the applicant, my lord. We have received the counter yesterday, my lord, in the matter 93, arbitration application 52 of.
What is?
I filed my
What do you say? What is your defense?
Yeah, defense.
He is praying for adjournment. That's why we are curious to know. What is it?
The agreement of sale which is there, lordship, that.
No, whatever you tell, like he is seeking an adjournment, right? Just what is your defense?
Defense is that agreement of sale are not existing, lordship. They are culminated into sale deeds. The agreement of sale dated 22/10/21 has been culminated into sale deed dated 17/12/21. So there is no contract subsisting is one objection. Second is that
was stating why you this thing.
No, I'm sorry, confused my colleague.
Let him not.
Yeah.
Don't do like this.
What's the count?
Yeah. And yes.
And second point I raised is that the agreement of sale is unstamped and unregistered.
Oh. Yes. Next week we will take up. You argue whatever. Let him appear. Why should you?
No.
Yeah. Yes. He was
There are
he was
other
telling us something. He was seeking adjournment only. Obviously, empty-handed, Mr. You shouldn't appear in the like this thing.
Your lordship.
We are planning to for youngsters like you. We are planning to this thing hold the orientation program for this thing to tell you the manners. You should never appear before the court empty-handed like this, right? Always with some other brief, but don't appear like this.
I'm available with the brief. I'm brought.
And try not to seek an adjournment, right?
The fact is that there are many legal issues to
Focus on arguing a matter instead of inventing how to seek an adjournment, right?
You're always excited for the opportunity available before your lordship. But counter will file yesterday.
That's the advice to you, both of you young people. Yes. Learn this petition.
I'm sorry, my lords.
94. Next week.
Yes, sir. I was actually ready, my lords. I was in another court.
Ah,
I am the counsel for, I am the petitioner. And
He was praying for adjournment.
He was praying, my lords, because I had instructed him
All
that
right.
I am not able to
Fine.
come.
Next week.
Very well, my lords. I'm obliged, your lordship. Obliged.
Yes.
May you please, your lordship.
Lordship, I am appearing for respondent. Lordship, I have a inconvenience.
Senior counsel.
Amravati High Court in a special bench.
Huh?
I'm in Amravati High Court in a special bench constituted pursuant to Supreme Court orders. I've informed my learned friend yesterday itself that I'll take adjournment to next week.
I am for the respondent, one first respondent.
Ah.
Yesterday we have informed this because the counsel was coming from outside for the petitioner. We informed him that today it would not possible for the, because there was a special bench lordship in the High Court that we could not, senior could not make today. So we requested him lordship there.
So you should have made an alternative arrangement. This is also a special bench, right? I don't sit single except on a Friday.
Only request.
So what is this, Mr.? You have the guts to tell the Chief Justice of Telangana High Court that Andhra Pradesh has special bench. This is also a special bench. Prayer rejected. Yeah, go ahead. This is too much. I mean, taking things for granted. What is this? You could have said that on account of personal difficulty, I am not ready, whatever. Can this be a ground? This is also a special bench.
That is not my intention, lordship.
No.
I'm extremely sorry, lordship.
Nobody's intention, right? I'll slap you and say no intention to slap you.
Not like that.
It's like this. Yes.
Factual
This is, no, mister. We want to emphasize upon you that this is also a special bench. And not less in any manner than Andhra Pradesh High Court. And you sooner you realize, the better it is.
No, it's not my intention.
No.
It's not my intention.
You please argue if you want to, otherwise I am going to pass an order.
Lordship, may I make a mention?
Lords, I am ready.
No, please argue, mister. Please argue. Forget about it. This ground is rejected. That special bench is constituted. If you want, I will write in the order. This is also a special bench. Yes.
Lordship, may I make a mention?
Yes, please. Who wants to argue? Yes, go
May I
ahead.
make a mention?
I am for the petitioner, my lord.
Yes, please.
May I make a mention in
For your
this
lordship.
Yes, please.
Is an
Lordship, may I make a
application.
mention in this matter? If
Huh?
the Lordship can permission.
No, please go. Yes, yes, mister. What is it? Please go ahead.
Lord, it is an application under section 11(6).
Fine. What is the agreement?
My lord, now, my lord, the second respondent in this petition formed a special a
Lordship,
consortium.
may I
for
make a mention?
Agreement. Mister, agreement.
the project in
What is the agreement dated?
my lords.
You don't know. All right. Speak.
Lordship, may I make a mention, Your Lordship?
My lords, the first.
Lordship, may I make a mention?
Please argue your case, mister. It's not our case. I don't want appointment of an arbitrator. Don't leave it on us. If you are not unable to argue, then fine. I am looking at it because you are even unable to tell what is the agreement.
My lord, I am ready. My lord.
Which is the clause?
They are disturbing, that is why, my lord.
No. Please go ahead. Yes.
Yes, my lord. The second respondent.
May I make a mention?
Lord, I'll tell you little fact.
No, that is rejected, Mr. Prayer for adjournment is rejected. We will record the reason that you are seeking adjournment because a special bench has been constituted in Andhra Pradesh. That is no ground. This is also a special bench.
No, I was present. Lordship, I was present at last two occasions. I was present. Matter could not be taken up because it was last vacation day, working day. I was present on both the occasions.
No, Mr. Reddy, you are a senior person. You could have said that please grant an adjournment. But this the ground, this the ground seeking adjournment that special bench is constituted. Is this not a special bench?
I apologize.
No, please. I am very particular about this, Mr. Reddy. You be careful about it, at least in this vote. I don't like this sort of this thing that can this be a ground that a special bench is constituted. So don't appear. We will take care of the case.
No, we apologize, Your Lordships. Kindly have it next week. I was present last two occasions. Matter.
Yes, Mr. Next week.
Obliged.
List next week. Your juniors also to make a prayer like this. This is not fair.
Sorry, Lord.
Yes. You better don't follow your senior, mister, on these issues. Don't follow him. That special bench of Andhra Pradesh. What is this?
Sorry, Lord.
You read CPC. That a council is busy before another court. Basic law. is not a ground for adjournment. Read order 17. And you are telling a special bench that special bench is there. Don't follow your senior. I am telling you in his presence. Don't follow. This is not a good practice. And read order 17. Order 17 of CPC. Yes. Yes. Yes.
For the respondent, my lord.
Yes.
We have taken a ground about for mediation not being complete, my lord. Now we have no objection for appointment of an arbitrator.
Yes. So what is that? This petition has been filed under section 11 within bracket 6 of the arbitration and conciliation.
Arbitration application filed under section 11(4), Your Lordship. The arbitration clause is at page 27, Your Lordship. I kindly
27.
take
Yes. What do you say?
for work order, Your Lordship.
Lordship, my primary objection, Your Lordship, the arbitration clause which petitioner applicant is.
Page, madam, which page?
Your Lordship, kindly take page 27, Your Lordship.
27.
Clause 18, Your Lordship. May I read, Your Lordship?
Mutually negotiation, then it will be referred.
Lordship,
So there is no mutual negotiation, right?
My Lord.
1 minute. We are just trying to understand, madam. The presumption is the scope is not like full-fledged argument. It's nothing. It's a summary proceeding. We have to. There is an agreement which provides for arbitration. We are just trying to ascertain.
Yes,
there is
Lord.
nothing to argue in this case. In fact,
Yes, Lord.
until unless you are required. So, what is the objection?
Lordship, my primary
When the notice was sent
notice was.
and the agreement is dated.
Page 6.
Lordship,
Agreement dated 25/5/2019, Your Lordship. This is a work
Logic.
order, Your Lordship.
Work on.
Yes, Your Lordship.
All. So when was the notice sent?
Lordship, 28/1/23 is the date of the notice.
28/1/23. What is your reply? When did you send the reply?
Lordship, our reply is on page.
28/1/23 is the notice invoking arbitration clause, right? So what is your reply? When did you submit a reply?
Lordship, our reply is on 17/4/23, Your Lordship.
Ah.
Lordship, our reply and the counter, the main objection is the same thing, Your Lordship. The applicant has never approached the respondent for a mutual negotiation, Your Lordship.
There is no point, right? Now, yes, that's the only submission.
Lordship, my other submission, the disputes which have been raised by the applicant in his application, Your Lordship, we have disputed every of the disputes, stating that they did not complete their work properly, Your Lordship. In fact, there is no dispute arising for the
That we can't decide, right?
Before the arbitrator.
If there is if anybody asserts and you deny, that results in dispute. If she is asserting a claim which according to you is misconceived, that itself is a dispute.
Not to oblige, Your Lordship.
Right.
My only contention would be that the
Ah.
applicant never approached us, Your Lordship.
Yes, all right. What is yes, madam? Yes, what do you say?
Your Lordship, the work was completed and
What about this that you never made an attempt?
no, Your Lordship, several emails were sent, Your Lordship. May I kindly take, I've
You
filed
tell
it
us
as
the
an annexure.
dates, madam. Dates.
Sorry, Your Lordship.
Dates of email when
Yes, Your
when
Lordship.
they were saying.
Date 6/3/2021, Your Lordship, 3/5/2021. I have filed it as annexure P3 to P7, Your Lordship.
Dates only 6th.
All these emails have been sent to them requesting for the payments, Your Lordship. And when the legal notice was sent, legal notice was issued demanding the payment, Your Lordship.
So only 2 dates, madam.
Your Lordship.
6th May and 3rd 5.
No,
May.
Your Lordship, we have, I'll take Your Lordship to my arbitration.
No, we are only asking the dates, madam.
Yes, Your Lordship. It is 3/5/2021, Your Lordship, 15/5/2021, 27/12/2021, 10/1/2022,
Just a minute.
26/5/2021.
I am noting it down, right? I am not a stenographer, right?
I'm sorry, Your Lordship.
27/12.
27.
So you will be the, madam, if I don't comprehend, the loss will be yours. Right?
Yes, Your Lordship.
The object is not to say anything you feel like. 27/12.
27/12/2021, Your Lordship. 10/1/2022, 26/5/2022, 8/8/2022, Your Lordship.
So no response to these emails?
No response, Your Lordship. And Your Lordship, thereafter a legal
What
notice.
did you say in this thing? In these emails, what was the prayer made? To make payment of the amount.
Lordship, all the emails were a reminder for payment, Your Lordship, and we have made telephonic communication stating that the invoices raised by the applicant herself, Your Lordship, applicant themselves, Your Lordship, were not certified. The general
All right,
practice is the invoice when it's raised, it has to be sent to the respondent for certification, and after that, a payment would be
This
released.
petition, yes, this petition under section 11 within bracket Yes, Mr.
So this is an application under section 11(6) for appointment of arbitrator.
Yes.
Lord, my lord, this is a leave and license agreement entered into for cultivation of cardamom. My lord,
Oh, you had filed a petition also.
yes, my lord, sitting in division bench, my lord say
Yes.
order.
You see.
Yes, my
leave and agreement dated.
My lord, leave and license agreement dated 24/1/2022.
So it's an what grounds you are opposing?
Only one thing before my lords would request my friend. My lord, there are two schedules of property. There is, my lord, the petitioners 1, 2, and 3 own A schedule property for which the agreement is there. Petition number 4 owns B schedule property for which there is no agreement. We are seeking appointment of arbitrator on the ground of group of companies doctrine. My lords have heard, my lord, in division bench that judgment is passed, my lord, filed along with the reply affidavit. Your lordship may kindly see that.
We'll take it up next week, Mr.
Very well.
Next week? Yes, next week.
I got the respondent for the applicant, Your Lordship.
What? Yes.
It is arbitration on purchase of plots. There are two issues in this matter. One is the payment of stamp duty on the contract.
Oh.
And the other is
Yes.
there is no arbitrable dispute in this matter.
Oh.
Your Lordship, regarding the.
You have satisfied yourself with regard to this thing, stamp duty?
Yes, Your Lordship. We are countered, Your Lordship.
All right.
Your Lordship, this is
We'll hear you next week.
Yes, Your Lordship.
This next week. Yes.
I'm appearing on behalf of respondents in this matter, Your Lordships. My sincere apologies, I couldn't file the counter, Your Lordships. My sincere apologies, Your Lordships, I couldn't file the counter. Your Lordship may take it this matter up to
Next week.
Oh, bless you.
Merit counsel for respondent is for short. List next week.
Deeply obliged.
Yes.
My lords, I'm for the applicant in the item 101, my lords.
Yes.
My lords, this is regarding the dispute arisen out of the developmental agreement. Which has been entered on 25th October.
You are opposing the prayer, madam?
I'm for the respondent counsel, my lord.
You are opposing the prayer. What ground?
My lord, this application is filed under section 11, subsection 5 of the Arbitration Act. My lord, they have issued a notice raising a dispute on 14/8/2023, stating that the dispute is a single dispute, saying that the development.
What is the ground of stamp duty?
Arbitration clause itself is not a valid clause because clause 18 in the arbitration development GPA, the arbitration clause states that there shall be an appointment of arbitrators and the seat of arbitration is Hyderabad and the language of in arbitration is English, which is against section 10 of Arbitration Act. And the application is filed under section 11 subsection 5, stating that the procedure is not defined between the parties. So the honorable court.
We'll hear you next week. Next week, Mr.
My lords, one submission, they have filed a section 9 application in the city civil court, my lords. That may be taken on record. Now they are opposing. They went to the city civil court for interim.
Also, we will hear. This court is required to decide your application, right? We can't decide section 9. And that.
My lords, my only submission is that after invoking section 9, now they cannot take objections. Is my submission.
Find out the case law on this point, right? We will hear you next.
My lords. Yes, my lords.
Oblige, my lord.
Yes.
May I request for next week?
All right, next week.
I am for the respondent.
Next week. Yes. 103.
But I had appeared before the respondent in the original arbitration application. Now this is an application seeking for extension. We have notice will have to go to the parties because we have no instructions. So I tried to contact the party, but they are not.
Yes, right. You used to appear for respondent.
At point way back in earlier when I am in the arbitration application.
Issue notice of IA so and so to respondent.